on the webinar. We'll start in 5 minutes or so. You can, we're grouping now. So you'll hear us in about 5 minutes, maybe a few more. Thank you. People, let's take our seats. It's on. It's on. Ladies and gentlemen, can we take our seats?
Okay. Good evening. Good evening, Chief Justice Rabner, Associate Justice LaVecchia, members of the New Jersey Supreme Court, and distinguished alumni and guests. I actually almost said, may it please the court, because of everyone here. My name is Rose Guizan-Villazor. I am the interim dean of the Rutgers Law School Newark location. Thank you so much for being here tonight. Welcome to the 36th Annual Chief Justice Joseph Weintraub Lecture. The Chief Justice Joseph Weintraub Lecture series was established by the Rutgers Newark Law School Alumni Association in honor of the late Chief Justice of the New Jersey Supreme Court. The series was inaugurated in 1982 by the late Chief Justice Robert Willens. This is our first in-person lecture in almost 2 years. So, yes. I got goosebumps when I saw everybody start coming in. I'm so grateful that you are here tonight, and I'm also grateful to those of you who are viewing this and listening to it, joining us remotely. We're happy to be here. Just quickly, we have to keep our masks on the whole time, but we were able to get a special exemption for Justice LaVecchia, so when she's up here, she is able to deliver her remarks without her mask. So thank you again for complying with all of our the university's requirements. Before I end my welcoming remarks, I want to note that there are far too many luminaries in the room here tonight. No, please don't. But if I were to recognize every single one of you, it'll take all night, and we will take time away from the justice's remarks. But there are at least two people whose names I did want to mention. One is Justice Fabiana Pierre-Louis, who is here with us tonight, who, like Justice LaVecchia, is one of our graduates from the Camden location. And I also note the Supreme Court Justice nominee, Rachel Weintraub, is here tonight as well. Thank you for being here. I also thank the Alumni Association for sponsoring tonight's lecture, and particularly thank Alumni Association President Naomi Barclow for her leadership. Last but not least, thank you to my colleague, Rob Steinbaum, and his staff, including Nate Nakau and Liz Moore, for helping out with this event. Thank you so much. I will now turn over the mic to Naomi Barclow.
Good evening and welcome, members of the Judiciary, faculty, students, and fellow alumni to the 36th Annual Chief Justice Joseph Weintraub Lecture. First, I would just like to thank Dean Guizan-Villazor and Dean Steinbaum and the Law School for facilitating and co-sponsoring this event with the Alumni Association. We have a pretty incredible turnout this evening, both in person and via Zoom. For those of you who are unfamiliar with Chief Justice Weintraub's career and legacy, he was the second Chief Justice of the New Jersey Supreme Court. During his 16 years as Chief Justice, he became known for his clear and concise opinions, which were intended to be easily digested by lawyers, judges, and the public. His decisions were based not only on constitutional and statutory principles, but also on common sense, the public interest, and principles of equity and even human rights, such as in a case involving a migrant farm worker's access to government services. Justice Weintraub was also known for his analytical genius and deep understanding of constitutional law. He was not afraid to challenge conventional legal analysis in order to reach an equitable and just result. As one of Justice Weintraub's Weintraub's law clerks explained in a law review article published 1 year after the justice's retirement, the Weintraub court was a court of action in procedure, in administration, and in substantive law. Today, we commemorate the legacy of Chief Justice Weintraub through this lecture series. It is one of the Alumni Association's signature events each year, which it co-hosts with the law school. We are delighted to welcome as this year's lecturer, Senior Associate Supreme Court Justice Jaynee LaVecchia. Justice LaVecchia is currently the longest-serving justice on the court, having been appointed in 2000, the third longest-serving justice ever to serve on the Supreme Court, and the longest-serving female justice in state history. Since graduating Rutgers School of Law, Newark in 1979, Justice LaVecchia has dedicated the majority of her career to public service, serving as assistant counsel and deputy chief counsel to Governor Thomas Kean from 1986 through 1989, serving as director and chief administrative law judge for the Office of Administrative Law from 89 through 94, serving as the director of the Division of Law within the Department of Law and Public Safety from 94 through 98, and finally as the New Jersey Commissioner of Banking and Insurance from 1998 until her nomination to the Supreme Court in 2000. In her 21 years on the bench, Justice LaVecchia has authored more than 300 opinions on issues ranging from school funding, affordable housing, and equal pay, to the constitutional limits on legislative action and the scope of protections against unlawful searches and seizures under the Fourth Amendment and self-incrimination under the Fifth Amendment. Most recently, Justice LaVecchia had the honor of swearing in the first Black woman Supreme Court Justice and third Black Justice on the New Jersey Supreme Court, Fabiana Pierre-Louis, who is here today, also a graduate of Rutgers Law and the youngest justice ever to serve on the Supreme Court. Like Justice Weintraub, Justice LaVecchia has served with integrity, with excellence, and an unwavering commitment to justice. We are honored to have her as our 36th annual Chief Justice Joseph Weintraub Lecturer, and so without further ado, please join me in welcoming Justice LaVecchia.
I'm sorry that I'm the only one who gets to do this. Naomi, thank you for that beautiful introduction. Better turn on my speaker here. Can everyone hear me? Yeah. Okay. Thank you for that beautiful introduction. It was lovely. And I would like to say good evening to everyone. Thank you for being here. I am so honored beyond words to deliver this year's Weintraub Lecture, named after the second Chief Justice of the New Jersey Supreme Court. I would like to thank the Alumni Association and the Rutgers Law Review for hosting this series and inviting me to deliver the remarks tonight. Mark, I was thrilled when you reached out to me. And I want to give special thanks to the Dean and to Rob Steinbaum for everything they've done to make this event go smoothly. You went above and beyond. Thank you very much. I'd be remiss if I started my remarks without acknowledging how overwhelmed I feel at the luminaries that I'm looking at in this room and the ones that I know that are joining us on the live stream. There are people from the bench and bar, both state and federal, current and former, who are among the best and brightest lawyers and judges that we have seen in the state of New Jersey. And I'm honored by your presence here tonight. Also, so many of my former colleagues have come tonight or are watching on the live stream. I am aware that all three Chief Justices with whom I have served are either here, Chief Justice Azali, or watching on the live stream, and I am so grateful for their participation in this event. It means a lot to me also that we have so many people from the Rutgers Law School family, the faculty, administrators. I see a number of students in the audience and met them before I came into this room, and also alumni, as well as my many friends from the bar, many of my law clerks who are here tonight supporting me, and some of the dearest friends that I have in the world who made a trip to Newark tonight to be with me tonight. Thank you so much for being here or for watching. One last shout out, forgive me. My brother is hosting a watch party in Florida. And I'd like to say hello to all of them, and also to my stepdaughter Elise, who's watching in Pennsylvania. Now, as we all know, Chief Justice Vanderbilt was the architect of the modern judiciary here in New Jersey. His vision and his leadership led to the 1947 state constitution's refashioning of the judicial branch of government, and specifically the modern Supreme Court as we know it now. The new judiciary was designed to be more efficient, that was a high priority, and also, importantly, to be independent. The first Chief Justice sent the judiciary down that path with new court rules and his early decision in Winbury versus Salisbury, which, with its progeny of Busick v. Levine and State versus Leonardis later on, advanced those goals. But then the second Chief Justice, Joseph Weintraub, for whom this lecture is named, made a point of ensuring that independence and integrity became hallmarks of the judicial branch in practice. He recognized that the two go hand in hand, and he was keenly aware of the importance of the public's perception of the judiciary as independent and free of extraneous and improper influences. His reasoning is transparent for anyone who picks up and reads his seminal decision in re Matera. Now, although Matera is known as the case in which the court proclaimed its authority under the 1947 Constitution to impose discipline on members of the bench, it is remarkable, I suggest, for another reason. In it, the Chief Justice explored the themes of the public's perception of and faith in integrity and independence in the judiciary. And he made plain his belief that we had to have an independent judiciary at every level so that decisions would be accepted by litigants and the public at large as dispassionate rulings free of favoritism, influence, or bias. Now, I can recount by one degree of separation how Chief Justice Weintraub personally helped convey that message. It traces back to a morning early on in my career on the court when I was to address newly appointed municipal court judges. I mentioned to my spouse that I was to deliver remarks meant to instill the importance of judicial independence to the new judges, encouraging them not to feel beholden to their appointing authority, to whom they would have close proximity due to the local sourcing of municipal appointments. In other words, in order to promote the public's sense of municipal court impartiality, I was to encourage the new judges not to be reluctant to render decisions unpopular with the people who appointed them and who would be responsible for reappointment. "Oh," my husband said, "you're giving the 'it's okay to be ungrateful' speech." He explained to me that Chief Justice Weintraub had told him and the other law clerks in the Newark chambers shared by the Chief Justice and several other associate justices at the time about that talk when the chief went to give it during his clerkship year, as the chief told them he did every single year. So yes, I delivered the ungrateful speech. And I have thought from that time forward about the tradition that had begun with the late Chief Justice Weintraub. There is in that story the connection to my remarks tonight. When asked to deliver this lecture, it was suggested that given my anticipated retirement from the court, a look back on the past 21 years might be appropriate. That very helpful suggestion sparked my interest in focusing on judicial independence and its derivative. And I'm going to repeat tonight because it's simply so extraordinary. Over the course of these past 21 plus years, I have served with 21 different members of this court. Think about that. That is a unique amount of change in the composition of the court. It happens to be the most experienced by any justice in the history of the modern court. And I'll add that it is a dubious honor, to say the least. It is a circumstance that has roots, admittedly among others, in the historical fact that 2 justices were not reappointed for tenure during that time, and no explanation based on competence was ever cited to support those actions. When it first happened, the implications for the independence of the court and for the judiciary as a whole triggered overt discussion in press reports, at legal gatherings, and even in published articles that an affront to judicial independence had occurred. One published article here in the Rutgers Law Review, authored by my friend and colleague Justice Albin, considered those actions in historical context, comparing them to actions taken before the ratification of the 1947 Constitution and those that had followed up until that point in time. But my point here is not to repeat those discussions that appeared in the press or those articles. Although I have to admit, living through it, the experience seemed extraordinary compared to the historical experience. You see, I was a person who had seared into her memory the night Chief Justice Weintraub secured reappointment. I was on the Senate floor the night when the voting board was kept open for hours, while, among others, Governor Kane himself was on the phone to persuade a particular senator to cast the hoped-for 21st vote to grant the chief tenure. As described in a memoir, Governor Kane explained that despite ideological differences with certain of the Chief Justice's opinions, the governor viewed his reappointment nomination of Chief Justice Wilentz as providing important, demonstrative gubernatorial support for the very notion of judicial independence. The recollection of that night remains with me still. But let me come back from that historical digression and bring up why I even raised the past, because I do so for a very specific reason. To the extent that extensive turnover in the makeup of the court during my 21 years had the capacity to impact the judicial independence of the New Jersey Supreme Court, I want to address that concern, of course, through my personal experience, which leads to the prime point tonight. I can attest that judicial independence, in the most commonly thought of sense, and importantly, in other senses that merit identification and appreciation, persists on our state's highest court. Allow me to detail why I say that and what I base it on. The need to keep judicial officers and the judicial process, in this instance the Supreme Court, independent, unpolluted, to use the vernacular of Chief Justice Weintraub in the Matera case, from outside influence is what typically comes to mind when judicial independence is referenced. The concern is that when external influences are brought to bear, they will impact decision-making by judges. Now, does it even need to be said aloud that one does not want judges at any level looking over their shoulders when deciding cases? Of course not. Fear or the desire to curry favor does not belong as a factor in judicial decision-making. That very concern is at odds with the point of the ungrateful speech Chief Justice Weintraub worked to impart to new judges. From my vantage point, over what has transpired during the course of a significant number of years now, that worry, since dissipated over time, I would add, has not affected our court's functioning. Preliminarily, it bears noting that judicial independence does take many forms. The judicial branch is, of course, separate and independent from the other two branches. There's no doubt about that under the Constitution. But it functions cooperatively with the other two branches. Our court, like other courts, construes and applies legislative enactments in the cases that are brought for resolution. We do so even when declaring a result that is publicly unpopular, but accords with the law as it exists. An independent judiciary is at work when making such pronouncements that leave a change in the law to another branch of government. Fraternal Order of Police versus the City of Newark was just such an example of that. Similarly, at times, we are required to inform the legislature that the law is ineffective to secure a result and that legislative action is needed to cure a gap. Such was the case involving a statute controlling the extraterritorial reach of a specific criminal statute dealing with child endangerment, in a case captioned State versus Stamulakowski. And in more unusual settings, the judiciary has been called upon to resolve disputes between the other two branches of government. Such was the case in a fairly recent appeal involving the legislative review clause, which had been added to the state constitution. In that matter, the legislative and executive branches were at odds over the validity of an administrative regulation, and the court had to review that dispute, requiring the court to assess the standard of review that a court would apply in such an inter-branch dispute over the legislature's use of its own constitutional veto power. We did, in an opinion authored by Justice Patterson for the court. These are among the varied roles that an independent judiciary is typically called upon to play, roles that our court has played historically and in the last 2 decades alone. But judicial independence has another dimension. Independence, judicial independence, or any feared diminution of its demonstration, which is more often the way the topic gets introduced, is often evaluated based on instances of inter-branch tension and conflict in which strong institutional concerns run up against constitutional principles the court exists to protect. It falls to us at times to tell coordinate branches of government what they may wish not to hear, namely that actions taken in the legislative or executive arenas are inconsistent with the Constitution. And the court has not shied from doing so when those occasions have arisen, not historically and not presently. Certainly, the Robinson v. Cahill decisions during the 1970s provide dramatic examples from the past. But we have had other high-profile, if you will, matters during the past 21 years, one example of which can be found again in the realm of school funding. Here I refer to the court's 2011 requirement that the legislative and executive branches fully fund the approved school funding formula under the state's School Funding Reform Act of 2008, which was known as SAFRA. We ordered that for Abbott districts. The decision received much attention at the time and has been described by Rutgers' own Professor Trachtenberg as exemplifying the court's independence. Just in case there is anyone unfamiliar with the school funding litigation history in New Jersey, suffice it to say that beginning with the seminal Abbott v. Burke decision in 1985, our court has played an ongoing role in ensuring that the state's approach to educational financing satisfies the education clause of the state constitution. After decades of executive and legislative attempts to try to satisfy that constitutional right, the right of disadvantaged school children in under-resourced school districts to a thorough and efficient system of education, SAFRA finally provided a constitutionally permissive formula. After a studied review, our court allowed the new constitutionally adequate formula to go into operation, with its built-in mechanisms for review and adjustment after an initial 3-year period of implementation. Importantly, and this is key, the court finally released the executive and legislative branches from all prior Abbott funding orders, in order to allow the SAFRA funding scheme to function as it was legislatively created to. The moment of release was short-lived, as the executive branch reneged in the ensuing fiscal year on the explicit promise to follow the SAFRA funding scheme. The matter returned to the court. The governmental institution whose responsibilities include control over appointments to the court sought to escape a promise of constitutional magnitude it had made. Grounding our analysis in the constitutional mandate and the conditions under which the state had been released from the prior judicial orders that had controlled education funding to Abbott districts, the court's decision delivered the strong medicine required, an order that enforced SAFRA funding to Abbott districts. That order was demonstrative of our court's commitment to the rule of law, notwithstanding its being drawn into interbranch confrontation. The constitutional guarantee at stake would not bend with the political winds. And not long thereafter, there occurred another demonstration of just such judicial action implicating interbranch dynamics with the court, this time in the area of affordable housing. Decades ago, our court had identified a state constitutional duty that municipalities exercise their zoning power to create an adequate supply of affordable housing. And ultimately, the court had to create a judicial enforcement remedy, although it was noted that a legislative solution would have been preferable. Eventually, the Fair Housing Act was passed, and through it, the legislature established the Council on Affordable Housing, COA as it's known, to be the agency responsible for the periodic assessment and approval of fair share affordable housing requirements for municipalities. The system presented the means for municipalities to avoid the judicial builder's remedy that had been the only remedy available prior to the legislation. Now, municipalities had another avenue to pursue affirmatively and thereby avoid that litigation. Well, the court's cooperative venture with the legislative solution lasted for many years, but then it collapsed, requiring the court to again demonstrate its fidelity to already articulated constitutional principles. COA had become moribund through executive inaction, and the defunct agency could not be permitted to stymie constitutional obligations. When the case returned to us, the court's decision and order created a new process for litigation to proceed again in the courts, and we enforced the constitutional obligation as case law had developed them. The court was unanimous in doing so. Our action exemplified necessary independence from the other branches of government with which the court plainly must deal on other matters. But when it comes to judicial matters, ones implicating constitutional principles and past constitutional precedent, interbranch dynamics, and any personal prior loyalty to having worked with or in another branch of government posed no impediment to the discharge of judicial responsibilities. Now, having mentioned those, I have to point out that dramatic cases like Abbott and COA do not come along frequently, which is why I chose tonight to shine a light on other equally critical aspects of a healthy and necessary judicial independence. The framers of the federal Constitution, as well as the delegates and speakers at the New Jersey State Constitutional Convention that led to the present Constitution, certainly viewed the idea of an independent judiciary as essential for the health of a democratic form of government at each respective level. As often detailed, the most ready explanation is legitimacy. It is essential that the judiciary be perceived as independent to litigants, so they may believe that they are being treated fairly and having their decisions addressed on the merits and the merits only, and will accept the results of the judicial dispute resolution process. That is, of course, beyond question. But I submit that there are other positive externalities that come from truly independent courts. Beyond promoting legitimacy, independence, I submit, is essential to substantive progress in our legal landscape. Judicial independence fosters the environment for independently thinking judges, and that area of positive results deserves attention, for it has been exemplified by the unabated independence shown by the New Jersey Supreme Court, both historically and during the 2+ decades I have been a participant witness in its work. I will highlight 3 ways in which the court has continued to demonstrate that independence of thought aspect to judicial independence. One is in the area of constitutional rights. I'm looking at Justice Pollack now. Scholarly writings, as well as judicial decisions, note that state constitutions and state Supreme Courts serve an important role in preserving constitutional rights, at times expanding fundamental rights beyond the minimum preserved under the federal Constitution. Leaving aside debate over the various views of how to assess when state constitutional divergence from federal constitutional rights should occur, Justice Pollack is an expert on that, issuing a holding recognizing that an expansion is necessary in a particular matter is itself a manifestation of judicial independence, I submit to you. It is up to the New Jersey Supreme Court to serve and protect the unique rights and needs of New Jersey citizens, as they are meant to be guaranteed through construction of the New Jersey Constitution, informed by state policy, interests, customs, and concerns. Or a lower floor to a constitutional right may make sense when uniformly applied to the 50 states through the U.S. Supreme Court, and even maintained at that level by a particular state through its highest court. That might not be so here in New Jersey. Our case law is replete with instances when our court has recognized that the New Jersey Constitution provides greater protection in a particular area. Focusing, if you will permit me, on the example of the Fourth Amendment's protections against unreasonable searches and seizures, and its essentially identically worded language in Article 1, Paragraph 7 of the state constitution. Our court has cut its own path from that set by the U.S. Supreme Court, despite the lack of textual differences between the two provisions. In 1980, our court flat out stated that the state constitution affords, quote, greater protection against unreasonable searches and seizures than does the Fourth Amendment. That was State versus Novembrino. Decisions exemplifying that heightened protection go back and forward in time from Novembrino's pronouncement. For example, back in 1975, Justice Sullivan, writing for the court in State v. Johnson, rejected the U.S. Supreme Court's approach in Schlecknoth versus Bustamante regarding the exception to the warrant requirement when there is consent to search, and held that under our Constitution, the state would be required to prove, as a necessary predicate, that a person has knowledge of the right to refuse consent in order to establish that the state has properly obtained consent to search. The line of holdings concerning New Jersey's expanded search and seizure protections continued into the 1980s with State v. Hunt and State v. Malika, finding a privacy interest in certain telephone billing records. And similar holdings continued into the time I have spent on the court, with Chief Justice Zali's decision in State versus McAllister, finding a reasonable expectation of privacy in bank records, notwithstanding that third parties have their hands on those documents. Bank officials will be touching them and handling them during transactions. But people have a reasonable expectation of privacy in their personal records. And then there were two more decisions by Chief Justice Rabner in State v. Reed, recognizing a reasonable expectation of privacy in internet subscriber information, and State v. Earls, requiring a search warrant before police obtained cell phone location data. As an aside, I would note, after that decision came down, 5 years later, the U.S. Supreme Court evidently followed our path when it similarly held in a case captioned Carpenter versus United States. But I don't have to look that far in the past. Just past this past court term, the court issued an important addition to that growing list. In State versus Roman Rosado, a driver was pulled over because the bottom portion of his license plate had the words Garden State partially concealed because of the way the license plate frame fit. The phrase was otherwise legible, but the stop led to the discovery of a gun and criminal charges being brought against the defendant. The defendant tried to suppress the evidence of the gun, but when the motion to suppress was denied, the case eventually wound its way up to us. We first determined that the applicable statute that prohibits concealing or obscuring marks on a license plate was not violated by a partial covering of the phrase Garden State. But as an alternative argument, the state asserted that even if the statute did not prohibit the defendant's particular license plate frame, the officer had made a reasonable mistake of law in interpreting the statute and pulling over the defendant. You see, in 2014, the U.S. Supreme Court had held that a vehicular stop premised on a reasonable mistake of law does not violate the Fourth Amendment's prohibition on unreasonable searches and seizures. In our case, Roman Rosado, citing Novembrino for our tradition of providing greater protection under the state constitution, we declined to adopt the reasonable mistake of law exception under our state constitution. As our court saw it, what was at stake was not whether the officer acted reasonably and erred about the meaning of a statute. It's whether a person's rights were violated. The court's opinion, which was penned by our Chief Justice Rabner, stated, quote, "Under our Constitution, it is simply not reasonable to restrict someone's liberty for behavior no actual law condemns, even when an officer mistakenly, although reasonably, misinterprets the meaning of a statute." For me, that single sentence captures our reason for differing with the U.S. Supreme Court. Independence, and I suggest, needless to say, metal, are involved when deviating from what the U.S. Supreme Court holds to be a constitutionally permissible degree of error by law enforcement, especially when it seems a majority of states, under their respective constitutions, agree. But in New Jersey, we continue to blaze our own trail in this area. No doubt some have had their doubts when this court has done so. Some may still harbor some doubts. The court's decision in State versus Hempley was met with mixed reception based on visceral reactions to our court's finding that warrantless police searches of one's curbside trash were unreasonable under our state's constitutional protections. But expectations of privacy deserve more than a visceral reaction. As Chief Justice Poritz's discussion of Hempley in her Weintraub lecture demonstrated, when she taught that case to a class of law students in another state that happens to live under the federal rule, they were quite concerned when they realized they were not under the same rule as in New Jersey, even though they scoffed at the decision at the outset of the class. I submit that it is when due consideration is given that the wisdom of the court's holding in that case is made plain to see. And I would posit that to give up such privacy now would seem a shocking reversal of protection for New Jersey citizens. I say that without disputing the brilliance or acumen of the jurists who compose the U.S. Supreme Court. But our highest court is more attuned to the particular needs and values of this state, which inform expectations of privacy and reasonableness considerations in search and seizure matters. Independent thinking equips our court's members to act based on that greater familiarity in properly developed records in our own matters, and encourages the legal community and the public to accept our decisions. Our court is, as has been noted in another Weintraub lecture on state constitutional adjudication, a court that, in my view, to this day, remains, quote, willing to entertain and discuss argument rooted in the individual rights provisions of the New Jersey Constitution. Now, beyond constitutional rights, this court's judicial independence and concomitant independence of thought are demonstrated in two other areas that I believe deserve attention. For one, they have found expression time and again in innovative procedural requirements imposed by the court to ensure fairness in proceedings. Steps taken using the court's constitutionally granted superintendent's power over judicial proceedings. Sometimes those steps are modest improvements to the fairness of proceedings, such as when we introduced the Fair Conference for preventative case management use in professional negligence matters, so that the salutary addition of the legislatively required affidavit of merit would not prove to be a trap for the unwary, and would instead be used, quote, to bring a swift demise to frivolous lawsuits while allowing meritorious ones to have their day in court. Sometimes, though, this court's superintendent's power is wielded for more sweeping improvements. 10 years ago, that authority and independence was employed when the court crafted a new path in eyewitness identification procedures in a little case called State versus Henderson. The steps required by our court moved the new procedures, which address the reliability of such identifications and their use in trials, into prominence nationally during the ensuing decade, which has resulted in that court's citation and consideration in appellate courts from coast to coast. Almost 3/4 of the 50 states have cited and reckoned with that decision when they've grappled with their own issue in their appellate courts. Similarly, our court's administrative steps to study and then promote bail reform led to a major legislative initiative whereby New Jersey became the first jurisdiction to implement statewide bail reform practices. But again, I do not have to point to examples from the past, even those fairly recent examples that I just alluded to. Just last term, the court again exercised such independence of thought and action. The court took novel steps to recognize implicit bias in the jury selection process and called for steps to study and curb it in a case called State versus Andahar. Independence is the cousin to courage, the courage to act and to act first, as independent jurists perceive necessary to promote just proceedings. Complacency with the status quo risks a sclerotic judiciary, rigid, unresponsive, and unable to adapt to contemporary legal practice needs and notions of justice. One need only consider the court's practically molded and yet constitutionally sensitive adjustments to remote grand and petit jury procedures during the challenges posed by a pandemic, where the court found ways to advance the justice system, protect the public, and maintain fairness to litigants. Justices Albin and Solomon described in their respective decisions for the court in Vega Larregue and Dangsil how and why the court exercised its power to adapt proceedings to new and extraordinary challenges just last term. The final area that I'll be highlighting tonight for its demonstration of the court's independence of thought is not the least in importance. One of the court's chief responsibilities is stewardship over the common law's development, an area in which, quote, the power of growth is inherent, as our court said back in 1957 in State versus Culver. The common law is not static, and judges of all stripes have recognized that, no matter the characterization placed upon them. As he often did, the great learned Hand may have put it best when he compared the common law's incremental development to the accretional development of a coral reef. Our court has long recognized and acted on its obligation to infuse case-developed law with vibrancy to address new needs and current societal values. The court has allowed expansion of common law duties as modern problems presented themselves, even when we acted ahead of the legislature or of sister jurisdictions, or in ways in contradiction to other jurisdictions. A perfect example of the court's deeply rooted tradition of innovative thinking in the common law's development is Chief Justice Weintraub's own opinion in Henningsen versus Bloomfield Motors. Henningsen is an example of the court breaking from past constraints on how to analyze a novel claim, specifically a claim involving defective merchandise placed into the stream of commerce. The court in Henningsen refused to limit relief on the basis of privity between the injured plaintiffs and the defendants, and proceeded to issue groundbreaking rulings that led to the nation's evolution of the law concerning product safety. Kelly versus Grinnell is another example. There, Chief Justice Wilentz, writing for the court, held that a social host in his own home, who provides liquor directly to a social guest and continues to do so beyond the point at which the guest appears intoxicated, and the host knows that, and knowing that the person will shortly get behind the wheel of a motor vehicle, will be liable for the foreseeable consequences to third parties for the results of that drunk driving. And one can point to still another past example in a different area, Pierce versus Ortho Pharmaceutical. In that case, the court acted to protect at-will employees who typically have few rights, but the court protected them from employment retaliation for whistleblowing, an area where the courts led and the legislature followed with statutory whistleblower protections through the enactment of the Conscientious Employee Protection Act. Perhaps the best historical example of such independent thinking came in the area of premises liability, specifically the case of Hopkins versus Fox and Lazo Realtors, which is the case that expanded premises liability and recognized that a realtor conducting an open house of a residence listed for sale owed a duty of care to a potential customer who was injured while inspecting the property. As noted in the Hopkins decision, our common law approach to premises liability had depended on the status of the person on the property at the time of injury, and the duty that was owed to the owner or occupier was then gauged by the right of that person to be on the land. In Hopkins, the court deviated from that formerly strict perspective of the status of the visitor on the premises, and instead determined that justice required a full duty analysis, that would be more appropriate. The court laid out general principles for considering when it would be fair to expand a duty and explain the factors that should guide such an analysis in the future. showing again the type of independence of thought secured through a robust and healthy judicial independence. Now, during my time on the court, that common law development has continued. Keeping just in the area of premises liability, the court took the principles expounded in Hopkins and advanced premises liability in a direction that at the time, as I recall, was ahead of all but one jurisdiction in the nation. The case was Alivo versus Owens, Illinois. In Alivo, the court considered whether a defendant could be liable for asbestos exposure, not only to those people working on the defendant's premises, but to those who could foreseeably be exposed to the asbestos carried off the premises. In that instance, a worker was exposed to asbestos while at work on the defendant's property. The asbestos contaminated his work clothes and eventually subjected the worker's wife, to exposure from that asbestos when she laundered his clothing. In determining to extend the defendant's duty of care to the spouse, the court resisted a status-based analysis and instead looked more holistically to the use of the Hopkins factors in our analysis in order to expand that duty. And premises liability, I should add, is not the only example of a duty expansion as of late. Just last term, social host liability also experienced an expansion in the state of Narleski versus Gomes. In that case, we opened the door to social host liability in a case that involved an underage adult who controlled access to his home, it was his parents' home, where a guest was allegedly allowed to drink to a state of visible intoxication and then drive, leading to third-party injury. The court closed a gap that was left open in the wake of Kelly versus Grinnell and subsequent legislative enactments. In all these settings, judicial independence provides the thematic score for the law's development and growth. Now, I know I am not the first to acknowledge by any means that the common law is an edifice that is never finished, just like the cathedral in Barcelona, Spain, that is never completed. The challenge for a court of last resort is to ensure that the law remains responsive to new needs. A progressive vision is needed by the courts, aided, of course, by practitioners and scholars, to identify places where the common law is failing to support shared values that a developing society will recognize, protect, and promote. With an independent judiciary, we can have independently thinking judges, which is essential to the development of the state's common law and a key responsibility of the New Jersey Supreme Court. The work of a justice of the state Supreme Court like ours, a court of last resort, like that of a justice of the U.S. Supreme Court, requires self-discipline, because each of us is human, and yet we must be able to put aside personal predilections in the face of judicial responsibilities. That point was explained by Justice Felix Frankfurter in a famous essay called The Process of Judging in the Supreme Court, when back in 1954 he wrote to the effect that while judges do not cease to be themselves and do carry with them their experiences, the mark of a good judge, quote, worth his salt and in the grip of his function, is self-discipline. In other words, a judge must rely on his or her intellectual habits of self-discipline to actively push back against internal predilections and biases from prior influences when engaging in the judicial function. Now, of course, Justice Frankfurter provided examples of the performance of that form of judicial duty that he described. But I submit examples can be found right here in the work of our court were persons of varied backgrounds, including previously representing plaintiffs, doing defense work, and serving in the government in many roles and different forums, can put aside past representative advocacy and other policy work when becoming judges, and can join together in the court's development of the law, recognizing as appropriate new duties and protecting and promoting interests as evolving societal needs and public policy reveals. That is so very necessary in order that the law continue on the path of progress, so that buffeted by change and changing circumstances, it does not become brittle or hollow, hobgoblins to a vibrant common law system. Now, as I said at the outset, Chief Justice Weintraub was keenly aware of the importance of the public's perception of a judiciary that was independent, so its decisions would be accepted. His work to keep the judiciary so, in practice, enabled the progressive and independent thinking for which this court's decisions became extolled, and whose legacy we on the court are challenged by history to maintain. The New Jersey Supreme Court that I joined in 2000, and the court compositions before that, had a reputation for judicial independence, having taken on many high-profile controversies brought to it by litigants. But in my view, what they and subsequent court compositions have in common, and what empowered the court to be a national thought leader for the past 70-odd years, is the capacity for independent thinking, which is not only important to public acceptance of decisions, it is the necessary predicate, the key enzyme, if you will, to the fulfillment of the court's supervision of the law's development, the protection of constitutional rights, and the superintendence of the fairness of proceedings within our court system. The examples I highlighted tonight demonstrate how the independence of the judiciary is no mere aspirational slogan. It is a state of mind, beyond rejection of past loyalties and pleasing others, including other branches of government that may have helped us in the past or that are in a position to help, or worse, hurt the judiciary in the future. Hard policy decisions cannot be ducked by the court when properly raised in a litigated matter. In my experience, they are not. The hard calls brought to us are made, and that is how it should be, and that is how it must be. The judicial independence of mind of which I have spoken tonight has made me proud to be a member of this court, where gratitude for one's appointment and other extraneous influences are anathema to how we must operate in our judicial decision-making. Judicial independence is precarious, though. It is ultimately dependent on individuals It depends on how gubernatorial as well as advice and consent power is exercised. After all, it's not enough for a belief in an independent judiciary to endure among members of the court. It also requires the continued consent of our elected officials. And as I have stressed here, it is dependent on the fortitude of individual justices and judges. Over the past 21 plus years, I have witnessed real courage in action, intense, high-stakes matters, and in the other ways that I've discussed. The court that I have served on has demonstrated its independence through its legal thinking and development of the law, its sturdiness in the face of political maelstroms, and its innovations in procedures as societal challenges and social sciences have demonstrated the need and the justification. The individuals who have peopled peopled the bench with me on the New Jersey Supreme Court, whether they were there for just a year or for longer, have had the necessary mettle and have labored to preserve the independence of this court, demonstrating repeatedly the ability to be open-minded and independent in thought and action, thus allowing the law to develop in all the ways I have highlighted. That independence of thought is what the court on which I still presently serve continues to advance. It is my fervent hope and my charge to future members of this court who will be responsible for its stewardship going forward, that it will always continue to be so. Thank you very much. Thank you. Thank you. Dean, did I turn the podium over to you?
Well, everyone, thank you for attending tonight's lecture. And for those of you who are staying for dinner, I believe that's upstairs. Right? Third floor? Third floor. But thank you all for coming. And thank you, Justice Jaynee LaVecchia, for such a wonderful lecture. I really enjoyed it, and I think everyone else did too.
Thank you.